In today's programme, I'll be discussing the case of Mr. C, which happened in the early 90s. Mr. C was a long-term patient in Broadmoor Psychiatric Hospital and developed gangrene in his leg, for which the recommended treatment was amputation. However, Mr. C refused surgery. But was his refusal valid, or was his mental illness clouding his judgment? In short, did Mr. C have the capacity to make a decision about his treatment? With me to explore these questions and to discuss the case are two people who were directly involved. Human rights lawyer Lucy Scott-Moncrieff, who acted as Mr. C's solicitor, and Professor Nigel Eastman, a forensic psychiatrist who gave evidence to the court. Also joining us is Professor Angus Wallace, who's been a doctor since the 70s and has witnessed the impact of Mr. C's story on how medicine is practiced. But first, let's return to the drama, beginning with Mr. Justice Thorpe, the judge in Mr. C's case, who reveals the High Court's decision.
C himself, throughout the hours that he spent in the proceedings, seemed ordinarily engaged and concerned. He was not always easy to understand, and the grandiose delusions were made manifest. But there was no sign of inappropriate emotional expression. His rejection of amputation seemed to result from sincerely held conviction. Although his general capacity is impaired by schizophrenia, it has not been established that he does not sufficiently understand the nature, purpose, and effects of the treatment he refuses. Indeed, I am satisfied that he has understood and retained the relevant treatment information, that in his own way he believes it, and that in the same fashion he has arrived at a clear choice.
Do you understand what I'm saying, Harold?
Of course I understand.
Well, what am I saying?
It might be helpful if you repeated it. You are saying, I have won?
You have won the right to self-determine, to make your own decision about whether you have the operation.
And I have won.
But you may die, Harold. It may be that you will never leave this hospital.
That's nonsense, Dr. Ghosh. I will not die. I will never die. I will leave this hospital on my own two legs, and I will live forever.
If that's what you believe, Harold, then, well, I don't know what to say.
So Mr. C won his legal case. The court decided that despite his schizophrenia, he had the capacity to refuse the amputation. I'm joined in the studio by two people who were directly involved in Mr. C's case. Starting with you, Nigel Eastman, you gave evidence to the court in the case. When you heard the decision, what did you think?
Well, I try always not to have an interest in what the outcome of a case will be, because I think it's very difficult to be objective in your evidence if you do have an opinion. But I think my reaction was pleasure that the law had been taken further forward, that the test for legal capacity had become more focused and more specific, and I think therefore easier for clinicians to operate. Dr. Ghosh, as the treating doctor, who I knew very well and practiced as an extremely conscientious doctor, adopted a paternalistic approach to the case. She saw it as her duty to care for the patient, but she essentially said he has schizophrenia, he is in Broadmoor, he's not a farmer in Cornwall, and therefore he lacks capacity. I would say that was wrong, that what you have to look at is the detail of the person's thinking and perception within the illness. You can't just look at the nature of the illness.
For Mr. C himself, did you think the decision was a good decision?
From the sidelines, I thought that he was a man who was able, as I said in evidence, he was able to make the decision in the terms of the threefold test that Lord Justice Thorpe adopted. And so in that sense, I thought it was a good outcome for him, even though it might have resulted in his death.
Lucy Scott-Moncrieff, you were Harold's solicitor. What was your reaction when you heard the judgment?
Well, different to Nigel, although similarly complicated in the sense that I was extremely pleased in legal terms. I felt that Mr. C had been treated with respect, that his wishes had been respected properly, and that the law, which can sometimes seem to be there for people with resources and privilege and so on and so forth, was being brought to bear at an extremely high level for somebody who didn't have those advantages. So I was very pleased on that level. And it was also, of course, very nice to defy the might of the medical establishment. On a personal level, of course, I felt sad because I thought that he would die.
So what happened to Mr. C?
Well, rather brilliantly, he turned out to be correct in his medical diagnosis. He didn't have the amputation, the gangrene didn't spread, and he did go back to Broadmoor. I'm not sure if he was actually on two legs when he went back to Broadmoor, but he was certainly walking around with a stick and a crutch.
So he was right?
He was right, yeah. For the wrong reasons, but he was right.
Nigel, before this case, how did doctors think about capacity, or did they?
I don't think they did think about capacity. When I went into neurology and then psychiatry in 1980-81, I don't think I'd heard the word capacity pass the lips of a psychiatrist more than on a few occasions. And I remember very well doing a small piece of research at Oxford, and I went to see a very distinguished and very competent and highly ethical psychiatrist, senior person. And I put a tape recorder on the desk and said, I want to talk to you about capacity. It was a sort of qualitative study. And he smiled and then said, capacity, yes. And that was his contribution. He'd never thought about it before.
How extraordinary. Why was this?
I think because medicine generally was profoundly paternalistic. And in psychiatry, that paternalism was bolstered by a Mental Health Act, which was legally extremely paternalistic. And I think doctors used that legislation in order to do what they thought was best for their patient, as Dr. Ghosh clearly adopted. And I don't think the word capacity really crossed people's minds.
Angus Wallace, you worked as a surgeon in the 70s and 80s. How did you approach capacity then, before the case of Mr. C?
We took a more paternalistic attitude towards our patients at that time. I was training in general surgery and then moved into orthopaedics. And in general surgery in Newcastle, we really cared for our patients. And I looked after a number of patients who had legs which had a poor blood supply, were ischemic, and the patients were likely to die without surgery. And we would speak to the patients. Often the very elderly did not want to have an amputation. And if they did not want to have an amputation, we would then go and explain to their relatives that if they didn't have an amputation, then they were likely to die. And there was a fair degree of pressure applied by the relatives on the person they cared about to encourage them to have the amputation. So there was a bit of coercion that went on at that time, but we really cared for the patients. Perhaps we didn't listen to the patients as much then as we do now, but that was the way that we were brought up, to look after that situation at that time.
In this paternalistic environment, do you feel you always got it right?
I think that sometimes perhaps I didn't. One particular case I recall was a lady who'd had a complication after a planned operation that resulted in problem with the blood supply of the arm, and I had to advise the lady that she should have her arm amputated from the chest, and that leaves you with a terrible disability. And we did the amputation to save her life, but the quality of her life after that was not good. And I always wondered whether I'd made the right decision, and I don't think at the time that I perhaps gave her the choice I should have.
You've all mentioned paternalism, but Lucy, isn't paternalism sometimes warranted? We heard Dr. Ghosh, Mr. C's psychiatrist, saying that she was protecting him. She thought she was protecting him from death.
Yeah, and that is where you get a very different legal ethic to a medical ethic. You know, the medical ethic at that time certainly was paternalistic. The legal ethic has always been that you follow your client's instructions. And so for me, it was an absolute no-brainer when he said he didn't want to have his leg cut off. Well, we had to check out the issue of capacity, which is why I brought Nigel in. But people have got to have somebody who can speak up for them and articulate what it is that they want, using all the sort of knowledge of the law and so on and so forth. But it's that particular person's point of view. And this is an endless tension between doctors and lawyers, particularly in somewhere like Broadmoor. You know, I'd say to a doctor, oh, my client, your patient, is going to ask for this at the tribunal. And they say, right, OK. And then the next week I might say, oh, he's changed his mind, he's going to ask for this. And I remember one doctor saying to me, how can you bear to go on just changing just because your client isn't that unethical? And I said, well, actually, no, it's a different ethic, and that's the point. So it might have been better for him to have his leg off clinically, but then we would all be much better and healthier people if we took medical advice, I'm sure. But we don't, and we're allowed to make those choices.
Can I add something about
Yes, of
roles?
course.
Because Dr. Ghosh and Lucy had very polarised roles, if you like, speaking in terms of paternalism. The medical expert who gives evidence to a court is a doctor, but he's applying his medical skills to a legal process. And that's why I made the point earlier that it's crucially important to try to remain objective and not, in a sense, to care about the outcome. Of course, one humanly does care, but my position as a doctor was very different from Dr. Ghosh's position because I was there not as the treating doctor. And there is some advantage in that when you apply a medical process to legal decision-making.
Can I just make one other point as well?
Lucy.
Talking about how Harold got a solicitor. Harold got a solicitor because Chandra Ghosh thought it was really important that he should have a solicitor. So she might have been paternalistic or maternalistic possibly, but, she understood that it was important that his view was represented.
Nigel, we heard in the drama that you offered the court a way of assessing capacity. How did you come up with that?
Well, in the drama, it says it was off the top of my head. It wasn't quite. It was in the moment. It was off the top of my head, but it was something I'd thought about and written about and researched and so on. But also, I was aware of the work the Law Commission was doing towards the possibility of introduction of a mental capacity bill to Parliament and Mental Capacity Act, and so I was aware of lots of discussions. So I had done a lot of thinking about what the test might be. Although on the day I didn't take the test from a particular document, I did simply say on the day what came sort of to the top of my head, but hopefully what came to the top was reasonable.
And you were keen to emphasise, and we heard it in the drama, that it's about not what someone decides, but how someone decides. Is that the essence of capacity?
I think it is. It's an established legal principle, certainly now, that although in very rare circumstances the nature of the decision can be relevant to whether somebody has capacity, the essence of capacity or incapacity relates to how the person comes to the decision. It certainly isn't based on the status of having the illness called schizophrenia. It's to do with how the person with schizophrenia thinks about the issue at hand.
And it's not just relevant when we think about mental illness, it might be relevant when someone's confused or has a learning disability. Is that right?
Of course, and because essentially what you're doing is you're conducting a mental state examination which breaks down into bits, if you like, the aspects of a person's mental processes, and those can be interfered with by a variety of conditions, as you've described.
Lucy, what happened to the law after Mr. C's case?
The capacity bit was really interesting because in the judgment, Mr. Justice Thorpe's judgment, Nigel's three-part test came in and therefore became case law. The case law meant that if there was another court case by somebody else dealing with issues of capacity, and in fact Nigel and I were involved in another case not long after that, then that test would be applied, which is how the system works in this country. But it was greatly reinforced when the Mental Capacity Act came out in 2005, because a very similar version of the test was in the Mental Capacity Act, and that now applies not just on court cases, but on everyday cases. It applies when decisions are being made about where somebody might live, about what sort of education they might be having, for instance, if they've got learning difficulties. So it's an across-the-board standard now for assessing whether somebody has got capacity to make a particular decision. And then the rest of the Act is helping people to make the right decisions on behalf of those who don't have capacity.
So this is astonishing. Whenever a doctor has a question about somebody's capacity to make a decision, it all comes back to Mr. C.
Pretty much, yep.
When did you start to notice the impact of Mr. C's case in your hospital, Angus?
I don't think that the hospitals actually grabbed the essence of the Mental Capacity Act until it was 2005 it was brought in, and I don't think it was till 2007, 2008 that we started to pay a lot of attention to it, and we started to really respect the patient's wishes. And now it is part of our requirements. I have just completed a course which is an obligatory course for all doctors, which includes a section on the Mental Capacity Act.
So in practice, how does this work? How do you use the mental capacity test with your patients?
We want to know whether the patient understands who they are, where they are, what they're doing. And as long as we are comfortable with that, the patient's wishes are paramount. And sometimes the patient's wishes are illogical, and sometimes we have to question ourselves.
And Nigel, when somebody lacks capacity, what then? How on earth do doctors decide what they should do then?
Well, in the Mental Capacity Act, there's a second stage, if you like, which is called the best interest test. And that essentially adopts the approach, what would the individual have seen as in their best interest had they been able to make the decision? And so essentially what you're doing is gathering evidence towards that question. You may be asking relatives not what would they want to be done, but what the individual want to be done, what their religious views were, what their views about medical treatment were, and so on.
So what sorts of patients might a question arise? Angus?
This would arise with the elderly and those who have mental disabilities who are not able to understand what we are doing, what their problems are.
So we're thinking of somebody perhaps with a learning disability?
Learning disability, they're a group of patients who are a real issue for us to deal with. And yes, we have to make sure that even though they have a learning disability, they understand the problem and everybody is in agreement with their treatment.
So it's what they can understand rather than the fact that they happen to have a learning disability that's crucial.
Yes, I've treated a number of patients who have learning disabilities, and there's usually no problem because they know they've got a problem. They usually want it treated. It's just the consent process cannot take place with the individual themselves. We've got to get somebody else to get consent from, but they have to understand themselves what we are involved in doing.
So how are things different in the past when people lack capacity and they couldn't make decisions for themselves?
I have a personal situation where my father was in an intensive care unit, having had complications after his own operation. And he'd been suffering for a number of years. And he was on a ventilator, regained consciousness, and he basically demonstrated that he'd had enough. That was transmitted to myself and my mother. It's actually very hard because you then have to make the decision about turning off the ventilator, and that's not easy. If it's placed in the relatives' hands, it really becomes very difficult sometimes.
Could I add something? Because
Nigel.
Angus is distressed about the position he was put in. In those days, before Mr. C, before the Mental Capacity Act, which was in very early 1980s, so just before Mr. C happened.
Mine was 1981.
Yes, that is exactly what used to happen. The nearest relative would be asked, what do you want us to do? Now what we tell medical students and junior doctors and even senior doctors sometimes is the question to the relatives is not what do you want us to do, but what would he want to be done? It applies an approach which appears much more grounded in the person in whose interest this all should be.
So the pressure is taken off the relative.
The pressure is taken off the relative in an emotional sense, but it's also taken off the relative in a rational sense, in that it seems more right, if you like, that the proper question is what that individual would want to decide rather than what a relative would want to decide.
Lucy, another aspect of the law that the case of Mr. C clarified was about living wills. Now, that's when somebody decides in advance what they'd want to happen to them should they lose the capacity to make a decision.
Yes. In addition to saying that Mr. C did have capacity to make this decision, the judgment also endorsed the living will, and that was the first time that had happened in case law, that a living will in that way had been given legal authority. There was a point in time at which it was said, yes, it is possible for people to say in advance what they don't want to happen.
Angus, do you think that the mental capacity test, so allowing people to choose for themselves, has been a positive move?
On the whole, yes, but I think sometimes it's really difficult. And I enjoyed listening to Nigel's division of this ability to have capacity into three parts. And I totally agree with dividing it into three sections. The first section, does a patient have capacity to receive, comprehend and retain the relevant treatment information? That's very clear. We now understand that, and we are actually taught that and obliged to learn it very soundly and throughout our medical practice. Does the person have the capacity to believe that information? That is clear. The one area where I think we have problems is where the person might not have capacity to weigh the information in the balance and to make the right choice.
So in what kinds of patients would you tend to see this?
If you have an elderly patient and you talk to them about having an amputation, all they can think about is, I never want to live with an amputation. And they have great difficulty thinking beyond that. Can they be fitted with an artificial leg? What will it be like to mobilise with an artificial leg or in a wheelchair? And taking them through that thinking process, I think, is really difficult for doctors.
So these elderly patients might seem to have the ability to make a decision using the mental capacity test, but actually you worry about their ability to make a choice.
Yes. That decision making when you are older, when you are frailer, is really tricky, and some benefit from having to reflect and think about it, and they need help. And for that, for instance, we have amputation nurses who guide them through the possibilities. From the doctor's point of view or surgeon's point of view, it is actually quite difficult. And sometimes we are placed in situations where we actually have to go to the courts now, because we cannot make a decision with the patient ourselves.
And you regret that?
No, I think that it is a totally appropriate thing to do. I think that we shouldn't override the wishes of the patient, but we have to make absolutely sure that the wishes of the patient are the true wishes of the patient, and that's sometimes difficult.
Lucy, after the case was over, you were still concerned about Mr. C, and in fact you asked him to write a will. Why was that?
Well, we all thought that he was going to die. He had all this money because he hadn't spent his benefits for 30 years. He didn't have any family to leave it to, and it seemed a bit of a waste for it just to go to the government. So I suggested to him that he might like to leave it to charity or to his friends, indeed.
And what did he say?
Well, he thought about it for a bit, and then he said, yes, I would like to write a will, and I know who I want to leave all my money to. I want to leave it to myself. And I said, that's a bit unusual. And he said, well, I'll need the spending money after I die. And at that point, I realised that he'd probably never had capacity, because he didn't have an ordinary understanding of death. Because if you remember, that was what the judge was asking about. Do you believe that you might die? If he'd said, no, I don't believe I'm going to die, the judge probably would have said, well, you don't have capacity because you don't understand the consequences and so on. But because he said, yeah, I do believe I might die, the judge must have assumed that he had a normal understanding of what it was to die.
Nigel?
Well, I can remember asking Mr. C in meticulous detail about his understanding of death and prediction of it and so on. And my experience of him in that regard was very different. And what this emphasises is that how capacity can fluctuate. And it may well be that his capacity was different when he had the subsequent conversation with Lucy about a different matter, which was to do with money, which he was actually quite interested in. That his situation then might have been different from what it was with me. So I'm not surprised by it. And it's one of the problems of capacity assessment, that it A, has to be about a particular decision, and B, capacity can fluctuate.
It's extraordinary, isn't it, that this vulnerable, detained man changed everything about our freedom, everybody's freedom, to make choices.
Yes, fantastic.
It is extraordinary, and I think it's a rather wonderful legacy that he leaves behind, that a man who was from the bottom of the pile socially left a really rather wonderful legacy for the rest of us.
And looking back, Nigel, what are your thoughts about your role in Mr. C's story?
Well, as you gathered from the drama, I was very reticent about giving a view as to what the test should be. I suppose I feel sort of quietly pleased that it turned out as it did and that I had some hand in it.
And Lucy, how do you remember Mr. C?
He was amazing, really. I think that the little play gave a very good sense of the sort of person he was, very resilient, very robust. Considering he'd had schizophrenia for such a long time, he had an awful lot of character and was very sort of there and very present.
Sounds like you were quite fond of him.
I was, yes. He was a very engaging chap, and he was extremely stubborn, but very likeable.
Thank you all. Lucy Scott Moncrief, human rights lawyer and founder of the law firm ScoMo. Nigel Eastman, Emeritus Professor of Law and Ethics and Psychiatry at St George's University of London, and Angus Wallace, Professor of Orthopaedic Surgery at Queen's Medical Centre in Nottingham. We've heard how influential this case has been for us all, but what were the consequences for Harold, our Mr. C? We know that he survived his gangrene and, as he'd always predicted, was still able to get around on 2 legs. But did he, as he'd also predicted, live forever? Well, we're going to leave you now with what became of Mr. C, after, of course, he'd made legal history.
Peter!
Ah, Chandra.
Do you have a moment?
Of course. Are you here to see
I
me?
have a patient with a broken leg. She's having anxiety attacks. She's bipolar. No matter. Not your case. I wanted to talk to you about Harold, Mr. C.
Ah,
I've had news.
I see.
He sent me a postcard. The old rascal.
He told you to stop worrying so much? Where is he?
We transferred him to an old people's home. By the seaside. He's by the sea.
Dear Chandra, I'm thinking of you. I hope you're well. You should not worry so much. Harold. P.S. I am by the sea. The sun, it is shining.